Wouldn't be it. There we go. All right. All right. We'll restart. Good morning again, everybody. My name is Patrick Fife. I am LIBOR's general counsel. Welcome to the June legal update. If you have questions for me, that's great. Please put them in the chat. I'm going to look at it throughout the presentation. And just before I kick off the substantive part of today's CE class, I just like to always give you a reminder to check out LIBOR's website on a regular basis. There's a lot of information that you get from a lot of different sources, news sources, social media. It's not all reliable. When it comes to compliance, when it comes to industry updates, I think the trusted source that you should be going to on a regular basis is LIBOR. We work really hard to get you information, whether you're a broker, a salesperson, things to keep you compliant, new trends, new things that you need to be aware of. So lirealtor.com, make sure you're getting our weekly email. Comes every Thursday. Has a legal tip, usually something, and a lot of the topics today I'm going to cover are in those legal tips. They're also all categorized, summarized on the website. Again, it's lirealtor.com. Also, signing up for our events. We've got a lot of great events. There's one coming up in July. I was going to say this month. We're not quite there yet, another day. But in about a week, July 8th, in Queens, free CE classes. Usually there's at least, I'd say, close to one a month. This one is on buyer representation and also understanding some new OneKey products that have come out. Free in person in Queens, breakfast included. These are opportunities for you. That's really a benefit of being a LIBOR member is we offer a lot of free education like this class, opportunities for you to
Right.
stay compliant, stay knowledgeable on things that affect your business. So the QR code for that particular event is there on the screen. Feel free to register today after the class. And just again, take a look at our website just because there is so much information on there that will help you. Look at it once a week. It's always changing, and it's there to benefit you. The other thing I want to mention, and I'm going to get into some of the questions that come into our legal support center, is another great benefit of being a member of LIBOR is you get access to a free legal support center, uh, calls to an attorney who will answer questions about real estate issues you may be having. It's available 9 to 5, Monday through Friday. It's at our LIBOR number, 631-661-4800. It's extension 335. And the other benefit it's really for you and for me is that I also get to find out what all of you are asking about. What are the issues that you feel are impacting you? What are the questions you have? And it benefits me and you because I can then structure our legal tips based on the questions that are coming into the field. And I get a sense to know what might be troubling you and what might be a potential pitfall for the rest of our membership. So it's a great way for us to share information and learn what's troubling you. So what are the questions that have come in the past month or the issues? I will say the number one thing every month that we get questions about is rentals, rental related questions. So I do actually have a new subject that I'm going to cover today specifically on rentals. But that's definitely the number one thing we get questions about. Um, Also, probably once or twice a month, we do get questions about cold calling and is it finally allowed in New York? And the answer is right now, no. Cold calling continues to be against the law in New York because believe it or not, we are still under some type of declared state of emergency by our governor. The current one has to do with public order at correctional facilities. It has been extended 19 times, and it is in effect until at least July 18th. And cold calls are not allowed because we have a law in New York that says you cannot, not just real estate licensees, no one can make unsolicited phone calls or text messages to a member of the public during a declared state of emergency. unless you have a previous established business relationship with that person. And I know that a lot of you and like me have gotten calls from other people trying to sell you something. I do warn you that you have a license from the state of New York, and the state will investigate. If they get a complaint, they have an obligation to investigate it. And you can be fined up to $20,000 per call if there is a valid complaint made against you. So any other kind of marketing is allowed, but there is a huge risk and potential financial penalty associated with making cold calls. We, NYSAR, LIBOR, have been advocating to try to get this law changed. I know the New York State Assembly passed a law to change this, but it has not. I passed a bill to change this, but it has not yet been signed into law. So, as of now, when there is a declared state of emergency and we're in one through at least July 18th, potentially longer, you can't make cold calls. I will tell you that once this restriction is lifted, you will be notified. I'm sure NYSAR will notify you, LIBOR will notify you as well. But until you get that notice, cold calls continue to be unpermitted in New York. Here's a question actually came up twice this month, and I got it the other day from a member saying, look, my seller's going away for about 2 weeks. They don't want their property shown. Am I allowed to keep it active? It's a lawful instruction from a seller saying, I don't want my property shown. You have to abide by that, but can I keep it active on the MLS? The problem is, no, you can't keep it active on the MLS. There's a rule in the MLS that all MLS participants and subscribers have to abide by that says if you can't show a property for 3 or more days, it has to be changed to temporarily off market. And why is that? Well, because one of the obligations or conditions of you listing a property on the MLS is it's available. It's available to be shown by other cooperating brokers. So if you have it as active and you can't show it, you are basically at false advertising. So there is a rule. The rule has to be abided by. If a property can't be shown for 3 or more days, you need to change it to temporarily off market. This includes listings where there's an acceptable offer with no more showings, or there are no more showings, or any other reason. You have to either take it off market, or withdraw it or have it as temporarily off market. This another question came up. I got it from a member the other day, but it's also come in a couple of times in the past month or a couple of months to the Legal Support Center. And that has to do with, is there a new law in New York that regulates the sale of residential properties to institutional investors? And the answer is yes. There's actually been a law. It went into effect in 2025, and it establishes a 90-day waiting period. So the seller, 90-day waiting period before an institutional investor can make an offer on a 1 and 2 family home. So what does that mean? Well, first, what's an institutional investor? There's 3 conditions. It has to be an owner who owns 10 or more single family or 2 family residences. It has to manage pooled funds, acting as a fiduciary, and have at least $30 million in net value or assets under management. So it's truly institutional investors. So if you are someone who represents those types of buyers, you should be aware that they cannot make an offer on a 1 or 2 family home where the property hasn't been on the market for at least 90 days, or if there was a price change within the last 90 days. I think most of you probably don't deal with real estate or institutional investor clients, but if you do and they meet that definition, and you should certainly talk to your broker or your attorney if you have a client that's in that in that category. But if you are in that category dealing with those types of buyers, you also need to make sure that your client submits, there's a required form that if they are going to submit an offer on a particular property, one or two family homes. It only applies to one or two family homes, and it only applies to institutional investors that meet that definition. If you have questions about this, we have a legal tip on it. And I see a question, what's considered an institutional investor? I just went over that. 10 or more properties, single family or two family homes, $30 million in net value or assets under management, and they manage or receive funds pooled from investors. That's what's considered an institutional investor. So again, it's a very precise definition. If you have questions, look at the legal tip on the website, speak to your broker or speak to your counsel. But that is it's a pretty limited law that only affects that category of buyers. Here's a question that's come up. What happens, and I've seen this also in some recent ethics complaints that have been filed here at LIBOR. Um, uh, could it be an issue if I accidentally solicit a buyer who already has an exclusive buyer representation agreement with another buyer? I didn't know that this person was represented by another buyer broker, and I did business with them. Well, it can be, yes, it can be an issue. It can be a violation of the code of ethics, and interference with someone's contractual relationship. So if a buyer already has an existing exclusive agreement with another broker, standard of practice 16.5 says you can't solicit that buyer. Um, and so a lot of people will say, well, what if I didn't know? I didn't know. Well, you have an obligation to find out. That's the issue. Standard of practice 16.9 says you have to make reasonable efforts to determine if your prospective buyer already is subject to an exclusive buyer representation agreement. So how do you do that? Well, before you provide any substantive services to a prospective buyer, you should always be asking, and I would recommend that you document you asking, are you working with another realtor under a buyer representation agreement? You want to find that out. You have an ethical obligation to find that out. It's not enough to say, oh, I didn't know. It is something that you do need to find out. I've also been asked, well, what if somebody lies to me? Well, if someone lies to you, well, then it's not an ethical violation. I mean, if the prospective buyer says, no, I'm not working with anybody, and it turns out that they did have an exclusive buyer representation agreement, that's not an ethical violation. But again, it's important to document that you asked the question and that you received an answer from the buyer. And certainly, if you've never asked the question, the accidentally defense is not going to hold up on a code of ethics violation. What are the requirements to serve as a real estate office manager in New York? This has come up a few times from members, and it's relevant because there is actually a requirement in New York. It's a specifically defined role by law. It's not something that a broker can just say, I'm making you my office manager. There's a requirement. And that requirement is you must be an associate real estate broker for at least 2 of the last 4 years immediately preceding appointment. So a real estate salesperson cannot serve as an office manager. A non-licensee cannot serve as an office manager. So if you're a broker, really make sure that you are paying attention to this, because brokers can face liability if they appoint somebody to serve as an office manager who does not meet the state qualifications. Last question I just want to go over, and I was surprised to get this. It came from a broker who said their agent was challenging them on this, and they wanted to just get clarification. I think if an agent's challenging this, I think they immediately should be sent back for further training. Who signs the agency disclosure form in the case of dual agency? It has to be signed by both the buyer or tenant and the seller or landlord. Remember, dual agency means you're representing conflicting interests in a single transaction. So you need the informed written consent of all parties. prior to entering into dual agency. So both must sign, and the form should be provided at first substantive contact. That means before you get into negotiating price, terms, those types of things, before discussing anything outside of the four corners of the property listing. Um, all right. I see a couple questions coming in that's somewhat off topic. I will be around at the end of class for some additional questions. But in order to kind of stay on track with our time, I'm going to move on. So if I don't answer your question, and you still want to ask it, feel free to ask it at the end of class. All right. I do want to let everybody know just about two scams that are out there that have a little bit of a relationship between one another, and we've been hearing a lot about both. The first one is be on your toes about receiving fake Zoom or Team or video conference links from scammers. I've heard about this from so many of you. When I've taught it, I've gotten comments in the chat. Yes, this happened to me. It's part of a nationwide trend, and it's designed by these scammers to basically access your confidential information. These scammers are using real listing details to try to look legitimate. I think it's a lot easier with AI now for these scammers to make themselves look like real buyers or real sellers. So, what is this scam? How does it work? Typically, the scammer poses as a prospective buyer. I've also heard in some instances they've posed as a prospective seller. They're asking essentially, let's say you have a listing, they start asking you through email or text message very realistic, informed questions about a property. Someone's done their homework, they know who you are, they know what properties you've listed, they ask specific questions about the particular property you're listing. Maybe it's they want to know about making renovations to the bathroom, the location of a bedroom, where it is. And they say, I'm very interested. I definitely want to see the property. I'm willing to make an offer. I just need to get some more information before I move forward. I work a lot better in person. I'd rather, rather than just text you, can we get on a quick meeting? I'm going to send you a Zoom link. And that's where the scam starts. They're looking to get you interested, hook you in, get you quick. And when they send that Zoom link to you, and you click on it, it may install malware, which could give the scammer access to your email, your files. They may prompt you to update or think you make you seem like you need to update your Zoom software or your Teams software. And as a result, you wind up putting in your username or password for whether it's your email, something else. They may ask you to download updates that are actually malware. I've also heard that they may actually want to record you for some kind of future impersonation scams. It is a real potential problem. So what should you be looking out for? It's that urgency. They want to get an immediate video meeting and insist on using their link. I spoke to one broker who said they got this. They seemed a little bit suspicious. They said, you know what? I'm going to send you my link. And the scammer got a little bit agitated and said, no, I already sent you a link. Use mine. Anything like that. Don't fall for it. Don't click the link. Insist, require, if you're a broker, require your agents to use the brokerage's link and not to click on someone else's link. Best practices is always to control the meeting. Don't click on unknown links. I know most of you, you kind of been educated to not click on those links in emails, unsolicited emails. But again, I think what happens here, it's a little different because these people come at you really looking like legitimate buyers or in some cases sellers. The seller one, it's, hey, I saw that you sold the property down the street last month and you did a great job. And I know you got $950,000. I've got a property 2 blocks away, and I'm very interested in hiring you to do the same thing. I'm out of state. right now? Can we meet over video? I'm going to send you a link. And you're like, I want to get this listing. Don't do it. Say, okay, great. I'm going to send you, let's schedule a meeting. I'll send you a link, and do it on your own trusted platform or account. If you are a victim, immediately, change passwords, notify your broker, make a report to local law enforcement, FBI, and alert everyone else in your office, alert your colleagues. We've seen that these things tend to happen in cycles, where, it makes the rounds. The scammer tries to hit multiple people in the same office. There's also a tie-in, I think, to some of these vacant land sale scams. I've reported on this before. It's a growing problem. A recent survey, 62% of fraudulent real estate transactions involve vacant land. So it's another, area where these scammers are trying to get you to move quickly. They know that there's still a very low inventory, and they're hoping you are going to rush. Red flags of all of these scams. It's the urgency. It's trying to get you to move faster than you should because you're anxious to get this particular listing. And they want you to move quickly. And I'll tell you that these scams, I know in most instances they don't go forward. The attorney, the title company picks up on the fact that the person selling it is not the true owner. Well, there was recently a case in upstate New York this year where the transaction did go forward. So what happened is the true owner wound up filing a lawsuit. He said, you know what? I own a property. Title was transferred and I never transferred it. So he sued the buyer, who actually recorded a deed. That buyer had bought the property from a scammer, and that buyer actually paid $80,000 for this vacant piece of property upstate. And the buyer says, well, wait a second. I thought I bought from the owner. I had an attorney, I had a title company, I had a broker. And I bought a legitimate property. Well, turned out the transaction involved an impersonator that was posing as the seller. They forged the deed. They had a stolen notary stamp from out of state. And that closing wound up proceeding. It went forward, even though the seller never appeared. So what did the buyer do? Well, first, the person who owned the property, the true owners, filed this quiet title action, meaning that they wanted to establish, I still own it. I never sold it. The public records are now wrong. Well, the buyers said, well, I didn't do anything wrong, but you know who they did? What they did? They sued, or they brought a third party claim against everybody, including the real estate broker. So they brought in the broker, the attorney, the title company, and they alleged fraud, negligence. You should have known. Well, the broker's defense is, hey, I was tricked too. I didn't know. I was scammed as well. Well, the court allowed the claims for fraud and negligence to proceed against the real estate broker. The broker said, well, I didn't know. But the court said, you know what? You could have known. What did you do to find out? It's possible you should have known that this particular seller was not the real owner of the property. So the broker has a duty, and all of you have a duty to investigate. Make sure that the owner or the person that you're taking a listing from is really the owner of the property. And there can be really big consequences of taking a listing without the authority of the owner. There's legal complications, there's potential licensure issues, code of ethics violations. I can tell you we've had several ethics complaints filed against listing brokers who took listings from scammers, people who did not own the property. They were ethics complaints brought by, in some cases, the prospective buyer, some cases the true owner of the property, saying you listed my property without authorization. You didn't do your homework. So these things are real. I know a lot of times you hear about these scams. Oh, no one falls for it. I can tell you they happen. And there are real consequences if you fall for the scam. Even if the transaction doesn't go through, there's the risk of reputational damage. You're going to get a bad reputation. That true owner or that buyer is going to talk and say, hey, this person didn't verify who the owner of the property was. So I just always slow down. If you're taking a listing in particular, if it's going to be vacant land, you need to do a video meeting or an in-person meeting and make sure you're using your own link, right? Going back to that first scam we mentioned. Um, don't use the link of the scammer because they may be trying to scam you twice. If you get that call or that text or that email from someone selling vacant land, say, great. My policy is I require a Zoom meeting or an in-person meeting with you. I will send you a link for a meeting at 3 o'clock today or when you're available. Slow down and then do your homework. Make sure the seller provides you details. You want multiple forms of identification. If this is your policy and you apply it on all vacant land sale transactions, there's nothing wrong. I mean, you really want a belt and suspenders approach when it comes to vacant land. I can't stress enough that this is real, and we've had some of your fellow colleagues out there who have fallen victim for it and faced the consequences as a result. All right, we're going to switch topics now. I want to talk a little bit about advertising and what risks there are out there. And I know a lot of you say, oh, well, if I get fined by DOS, it's just one $500 fine. And that's some brokers may say that. It's not. There are real serious consequences for not advertising properly. And I will say that the Department of State will review all of your advertising if they get a complaint against you. So even if you get a frustrated buyer, let's say you're the listing agent, right? You list the property, you get multiple offers, your seller decides, I'm taking offer A, it was the highest and best offer. Frustrated buyer B says, I think they didn't present my offer. You did, but frustrated buyer B doesn't know that. Frustrated buyer B says, you know what? I'm going to complain to Department of State. And it's completely unfounded. You did nothing wrong. Well, Department of State may absolve you and say, you know what? You did nothing wrong. You did everything you were supposed to do. But because we got this complaint here, we just want to look at all of your advertising. So we're going to take a look at your website. We want you to provide your business cards. We also want you to give your records of CE, just completely unrelated, but they do that. If they open up a file on you for any reason, they are going to look at your advertising. So even an unfounded complaint can trigger a full audit, and that will include your website, possibly your social media, anything out there on you. And small technical violations can pile up. If you make the same mistake across multiple platforms, that could be multiple fines. If you're a broker and you have multiple agents doing all the same thing, or all of the pages on your website call your salespersons agents instead of salespersons, and you have 50 of them, that could be $500 fines that are attributable to you. So it's just really important that you make sure you are following all of the advertising regulations. When it comes to websites, remember, every website has to have a link to the New York State Housing and Anti-Discrimination Notice. That includes even websites maintained by salespersons, real estate teams. So teams, if you have a website, make sure you have a link to that notice. If you don't, you're at risk for a fine. Also, all brokerages websites, you need a link to the reasonable accommodation and modification notice. We'll talk about that a little bit later. But there's a notice that you have to give all prospective tenants, letting them know that they have the right to request a reasonable modification or accommodation in the case of a disability. You also have to have your broker standard operating procedures on all brokerage websites. And this is something required by all brokerages, but these three things you need to have on your corporate company brokerage website links to all three. And if you don't, you're at risk for a fine from Department of State. You also want to have your correct license name and title across the board on everything, including social media. So, remember that, you're not a licensed realtor. You're not a real estate agent. You take a look at what your license says. You're a real estate broker, an associate real estate broker, or a real estate salesperson. Those are the three titles that should be used, and the name on your license is what you should be advertising with. Um, Brokers, got some brokers. I know there's a couple in the audience because I know a few of you, and I saw the names of people who signed up. You're responsible for advertising. Legally, a salesperson or an associate real estate broker cannot advertise on their own. They need the broker's permission. So you're required as a broker to supervise all advertising, and you could be held responsible if your licensees do not advertise properly. So remember, it is the broker who has to authorize and approve all advertising. So just some best practices. Brokers, you should have policies. Have an advertising policy that implements, how everyone in your office needs to advertise. If you're a salesperson, get your broker's pre-approval. We've had salespersons call up and ask the legal support center, I just want to make sure I'm doing this properly. Great. Did you talk to your broker? Well, no. Well, there's your first mistake. Go back and do that. It's up to the broker to approve any kind of advertising. I encourage all brokers to have centralized templates, checklists, have guidelines for how advertising needs to be done. And I think all of you, whether you're a broker or an agent, do periodic audits of your own advertising. Every once in a while you might slip up. Just go back every 6 months and check what's on my social media, what's on my website. Did I do any new types of advertising, any kind of print, any kind of email? Is my signature block the way it should? And I've given you this as a handout. There's also a QR code here. The Department of State actually gives you the cheat sheet. They have a real estate advertising checklist. That's what they use when they're, when they're reviewing your advertising. And on that checklist, they say, following these rules may help you avoid fines or other discipline and help protect the public from misleading or inappropriate advertising. So look at it, use it every 6 months. Just take a look. It's 10 minutes. Just checklist, boom, boom, boom. Am I doing all these things or not? Real easy, and it can avoid the possibility of fines down the road. I will also let you know, Department of State is looking at the use of AI in advertising. There's no formal policy right now in New York. I was just at the NAR, the National Association of Realtors, mid-year conference, and they had a presentation or a number of presentations on AI. I will tell you that there are 1,800 pending or new laws in the United States right now concerning the use of AI. So I wouldn't be surprised if New York joins the fray and puts out some new laws or regulations concerning the use of AI specific to real estate. But they have said that as of now, they will apply the existing advertising regulations. So you need to remember that all of your advertising needs to be honest. It can't be misleading. It has to be accurate, and that you can't engage in any deceptive acts. So, very important that when you're using AI, that you are reviewing what you're putting out, and it's not a defense to say, "Hey, AI did it, I didn't." In fact, California just recently, a couple months ago, put out a warning to all of their licensees in their state saying, hey, that's not a defense. You have an obligation, and brokers have an obligation to supervise their agents' use of AI. And if you don't have any kinds of AI policies in effect, you as the broker could be liable if your agent uses AI to alter a photo and doesn't disclose that. Our Department of State here in New York did issue a warning back in November. And they said, hey, be aware. There is a rise of artificially generated pictures on real estate listings. And it's a trend, and they have concerns about accuracy and authenticity and the potential for false advertising. Again, they didn't make any specific changes to the laws, but the fact that they issued that warning to me is a sign that this is something they will take seriously. So, if you are going to use AI in your advertising, I think that's wonderful. But let's go back to one of my first warnings from today. Slow down, right? Make sure you're using it properly. If you're a broker, you should have an AI policy. NAR, National Association of Realtors, has a template policy for brokerages to use. It has some really good I think recommendations and some issues that you should all be aware of. I encourage every one of you to take a look at it. You can scan that QR code. It's just a good idea to get a better understanding of what the limitations of AI are, how you should be using it, what to be aware of as far as risks, and how to mitigate those risks. So please take a look at that template. And if you're a broker, certainly consider implementing a policy. But if you're an agent, you also do want to take a look and give it some thought. Next topic, and I do have a couple more to get through. I just want to let you know that you in New York, you have an obligation to be trustworthy 24/7. So what do I mean by that? Question. I mean, can your conduct outside of your real estate activity put you at risk? Some of you may think no. The Code of Ethics actually says not really. Code of Ethics, this is effective. It was a change that was made last year, said that you are only subject to disciplinary action under the Code of Ethics with respect to your capacity as real estate professionals and in association with your real estate business or in your real estate related activities. So Code of Ethics only limits you there. But New York State law actually goes further than the Code of Ethics. What I call off-duty conduct has been cited by the Department of State and the courts to support findings of untrustworthiness. This isn't really something that's new. Cases in New York courts going back to 1994 that says, hey, untrustworthiness, which can affect your license, is not limited to situations where the underlying acts or conduct are related to real estate transactions. And why am I bringing this up today in a legal update? Well, there's been two recent cases that came out of the Department of State that I just want to make you aware of. And they're cases where real estate licensees were disciplined for conduct that was what I would say is off duty, didn't really relate to their real estate related activity. So one of the cases involved a licensee making vulgar and racist comments in a text thread to a member of the public. It was somebody they had a former business relationship with in connection with a transaction. And ultimately that licensee's license was suspended. So they said, Department of State said, even though the comments were not made in connection with a transaction, it does not negate your responsibility as a real estate salesperson to act with professionalism, respect, and within the bounds of the law. Another recent example, a licensee directed racist and abusive epithets to a health club employee, and it was recorded on video. And the person who was subject to those complaints made a complaint to DOS, and that particular person's license was not, renewal was not granted. And Department of State said, hey, that video footage of the applicant's display of hostility and his use of racist and abusive epithets firmly prove his inability to treat certain members of a protected class fairly. So the warning to all of you is, look, your conduct matters. Whether it's in connection with a real estate transaction or not, you have an obligation to act as a professional at all times. And for that reason, I strongly encourage you to take a look and make sure that you do your best to follow. NAR has put out something called Pathways to Professionalism. It's a list of suggested professional courtesies and conduct. It's meant to supplement the code of ethics. I mentioned before, our realtor code of ethics only applies to your conduct within a transaction or as a real estate professional, but this kind of goes a step further. And in my view, it's a good way to make sure that you are being a professional that is trustworthy under New York law. So a couple of things in there is, be aware of and respect cultural differences. Show courtesy and respect to everyone. Avoid the inappropriate use of endearments or other denigrating language. And remember, real estate's a reputation business. What you do today may affect your reputation and business for years to come. So whether it's on social media, whether it's in text messages, whether it's in social interactions outside your real estate transactions, being a professional matters from a business standpoint, but it also can affect your license in New York. So make sure that you're aware of that. I mentioned at the beginning, I wanted to just talk about rentals and the risks associated with handling rentals. I'm not going to say that you shouldn't handle rentals, although that can be an option. But you should be aware that you need to know what you're doing if you're picking up a rental transaction. It is the biggest area of undercover testing in New York. And that is because it's easy. It's a lot easier for undercover testing of rentals to take place than it is of sales. It can just be a phone call. There is a heavy fair housing enforcement focus when it comes to rentals. Rentals are the highest volume of consumer complaints. I can't say we've done a study under the code of ethics concerning complaints, but I can just tell you from my experience a large number, maybe not the majority, but a large number of our ethics complaints that come into LIBOR, and I'm sure other associations deal with rentals. Um, there's a lot more regulation in rentals. There's a lot of overlapping regulations. You have city, state, federal. You've got commission regulation, at least in New York City, under the FAIR Act when it comes to rentals. So there's really this convergence of a lot of different things happening, and you really need to know what you're doing. You must have the competence to handle rentals. And it's also a big area for scammers. I definitely think that rental scams are more prevalent than sales scams just because they're quicker transactions. It's a lot easier for scammers to get involved. So you need to be careful. Fair housing, I mentioned it, but this is backed up. The Fair Housing Justice Center does an annual trends report. It's a national not-for-profit organization, and they found that out of all the fair housing complaints related to that come in, 83% relate to rentals. So the large majority have to do with rentals, and out of those, most of them then also relate to disability discrimination. So it's a hotbed for complaints, problems, and issues. What are the most common rental violations? Disability discrimination. I think within that, the number one is brokers, owners, managers treating service and emotional support animals like pets. They are not pets. Service and emotional support animals are tools to help someone overcome a disability. If you have questions about that, look at our website, read some of the articles. It's very clear how to avoid any kind of discrimination in that area. Lawful source of income discrimination. It's refusing, ghosting, meaning not responding, or frosting, meaning telling voucher holders, I'll get back to you, or the building will get back to you, and never doing it. You have to treat lawful source of income like any other protected class. Illegal fees, remember, application fees in New York are capped at $20. That's it. There's no application fees, showing fees, deposits to view a property. All of that is illegal. The FAIR Act. Since last year, the New York City Department of Consumer and Worker Protection has fielded well over 1,000 complaints under the Fair Act. Remember, under the Fair Act, the landlord's broker cannot receive any compensation from the tenant. They can't request commission from the tenant. This applies to all residential leases in New York City. Been the law for over a year now. Mishandling security deposits. I've got brokers illegally retaining, misplacing deposits, or owners charging more than 1 month security. All that a landlord can charge in New York collectively is 1 month security, nothing more. If there's a 1 month security deposit, they can't charge additional deposits for things like pets or anything else. Failure to disclose agency status. Agency disclosure is just as required and just as important in a rental transaction as it is in a purchase. There is an agency disclosure form for rentals. All of this, these are some of just the common violations. And I think it's only going to get worse. The use of AI. There's been some warnings that just came out about AI, basically algorithms that are used to screen tenants and the potential disparate impact and discrimination that occurs with those. So there's warnings about that. There's warnings about price fixing using AI when it comes to rentals. So a lot of risk out there. I encourage all brokers have procedures for rentals. If you're going to have agents that handle rentals, make sure that they engage in some kind of training. So you want to have specialized rental training. Have more transactional audits when it comes to rentals. Really scrutinize, make sure that agents are following the law, following your office policy. If you're a big enough brokerage, you should have experienced office managers, an office manager who specializes in rentals that can handle rental related issues. I mentioned the Fair Act. If your office handles any rentals in New York City, you absolutely have to be aware of this. We still get 4 to 5 calls a month to the Legal Support Center asking about the Fair Act. If you represent a landlord in New York City, you cannot pass along any fee to the tenant, including your commission fee. Applies to all residential apartments located in New York City. It's any fee. This is right from the law. A landlord's agent shall not impose any fee. There's no workarounds. It's any fee or collect any fee from a tenant related to the rental of residential property. Excuse me 1 second. Let me just grab some water. Make sure your listings aren't seeking an illegal or excessive security deposits. Another I mentioned, 1 month security. That's the maximum. No more than $20 for a credit or background check. No other fees are permitted. If your agents are out there, you're an agent charging an additional fee, you're breaking the law. And you can be held accountable not only by the tenant, but Department of State could look at it as a licensure issue. The Attorney General may look at it as well. Clear cooperation also applies. If you're going to take a residential rental, it has to be put in the MLS within 1 business day of marketing the property to the public. It includes rentals. There's no exclusion for residential rentals. Commercial properties, different. We're talking about residential rentals, but residential rentals are subject to the clear cooperation rule. Mention lawful source of income. Treat any individual with a voucher the same way you would anyone else. Don't ignore, don't refuse to return phone calls. If someone says they have a voucher, you treat them the same way. You ask them the same series of questions you would any other prospective tenant, such as where are you looking? What areas are you looking? How many bedrooms are you looking for? And what's your price range? Very important that you just, as a brokerage and as an agent, you have procedures that you follow for every single tenant, regardless of any protected class, including lawful source of income. I mentioned about your websites, that reasonable accommodation and modification notice. This is a form required by the New York State Division of Human Rights that you have to give all prospective tenants. So when you hand over that agency disclosure and your fair housing and anti-discrimination disclosure, you also need to hand them this form, and it lets them know, hey, you have the right as a tenant, if you're disabled, to request a reasonable modification or accommodation. Mention deposits, 1 month. That's it. There's no such thing as a pet deposit. If the landlord's already seeking that 1 month, they can't add on additional deposits. You can't have a pet deposit, a child deposit, anything like that. It's 1 month security, period, nothing more. Landlords can charge additional rent for pets. That is permitted. That's not a violation as long as that's disclosed as a fee. But you cannot charge it for service or emotional support animals. Can a brokerage or an individual agent have a no rentals policy? Yes. So, with all those warnings, right, and all those risks, what if you just decide, hey, I don't want to handle rentals? That's fine. You could be a broker. I know there are some brokerages out there, some smaller brokerages who say, I don't want to deal with the risk. My brokerage does not handle rentals. That is completely fine. That is up to you. My only warning, you just need to apply that consistently. So you don't want to say, hey, well, if somebody calls asking about that, really exclusive rental or that really high-end rental, and someone calls with a voucher, I'm going to treat them differently. Selective application can create a discrimination risk, but you absolutely have the right to have a policy, but you just should document that policy and enforce it uniformly. So, the call, if anybody asks about a rental and that's your policy, should be, I don't handle rentals. I can put you in touch with someone, or this office doesn't handle rentals at all. You would need to speak to another brokerage. Going to just wrap up really quick on just, I mentioned at the beginning why you should look at LIBOR as a trusted source versus some of the other I'll call them avenues to get your news or information about real estate. We mentioned source of income in Section 8. This was back in, I think, April or May, I did a search just about Section 8 and can landlords in New York refuse Section 8? And this is what came up in my Google News feed when I did that. I said, yeah, Section 8, New York landlords can now legally refuse vouchers after court ruling. There was a recent court ruling in March that said, yes, New York Section 8 lawful source of income law can't be used to require landlords to accept Section 8. Court said because it's forcing landlords to have warrantless inspections and provide access to records. So yes, a court did say that. But the reality is it didn't change anything. That's because that decision's been appealed. And in New York State, when the Attorney General files an appeal or the state files an appeal, the underlying decision is stayed, meaning it's not effective yet. So in New York, although you might Google it and AI might tell you something different, right now in New York, all lawful source of income protections, including Section 8, remain in full effect. So even, it's just, you have to continue to follow all source of income laws. That's why I just really urge you to be careful about what you read and what you hear and verify your information with a trusted source. Because if you just Google it, I didn't ask Claude or Copilot or ChatGPT, but the AI and search engines and news sources are not always accurate. Same thing when it goes to the issue, and this came out, I think in April or May. There was talk about, can realtors now talk about crime in schools? And if you just Google that, look on Google News, can realtors talk about crime in schools? Pulled up some articles that say, headline, Feds greenlight realtors to talk crime in schools again. And they're referring to an April letter from HUD that was sent to the real estate industry on that subject. But the reality is, no, in New York State has very broad fair housing enforcement. And New York State says, no, you need to be careful. You need to use caution about how these topics are discussed. You should not be giving subjective opinions, commentary, hearsay about schools. And there was a lot of information about this that was put out, but there is a risk. It's not the topic that's the risk, but it's how it's delivered. It's referring to schools as good, neighborhoods as safe. Remember, your role is to provide direct, objective information, point to sources. I want to point you, and I'll end here, just a legal tip, because I get this question, well, how do we address this issue? What should we do if someone asks us about schools, asks us about crime? We have a legal tip for that. We've got some guidance on what you can say and how you should approach that issue. You can scan the QR code. You can also go to the website, go to lirealtor.com, take a look at the legal tips. But in New York, it remains, a potential fair housing violation to talk, about subjectively about schools, about crime, about safety. It's not something, that you should be talking about. You should be pointing, consumers and clients to objective information, not your opinions. All right. So with that, I am done. All right. Well, I thank everybody for their time today and hope everybody has a great day.